here's my perspective, and we've all sat down, obviously, and wrote this program, but several of us, in fact, most of the panelists, we've been talking about this for well over 5 years. And really in the last 12 months, all 5 of us, and I know Bruce has been taking the lead with the subs, we've been chewing on this. And are trying to come up with some actual ways to make the process better. So, you know, what's my spin? My spin is, what I did is about a year ago, I took the ADR process and I sat back for about, Paul and I did, Paul Vio, and we re-engineered the ADR process, thinking that we were going to get rid of a lot of pieces of the ADR process that were not productive. What we found is we kept about 95% of the conventional ADR process. We simply retooled it and re-engineered it. Now, I'm not saying this is the answer. It's not. We all know there is not one answer. Every case is different. Every mediator is different. Every plaintiff attorney and defense attorney and package of subs is different. So what we said was, what's really the process? What's the problem? One of the problems with the process. And we said it's lack of active management. The CMO is not necessarily deficient. There's minimal, again, I'm a contractor. I'm used to, in the early days, I built lots of buildings. We put together CPM schedules so that we would know when that subcontractor was needed in 6 or 9 months. We knew what materials they were going to have, et cetera, et cetera. That's what we did to the process. And so we think that one of the necessary things is to actively manage the ADR process, which means you have to have a program to manage it in. Paul and I designed that program, and that's what we use. We also work the issues in parallel, and that's really what Gary was saying in particular. So rather than in series or in parallel, and I'm not going to show the presentation, but if you go to the website, LiMa's website, you'll see it. We do them in parallel, and we have what we call 4 lanes of traffic on the road to resolution. And so we help the mediators maintain this. And I can't tell you how many mediators I have met with in the last 30 days. I thought I knew them all. I think I do know them all, actually. But everyone that I've met with has said, you know, I need help managing the process. And there are various reasons why. The average attorney, the average mediator, is not a good project manager. And that's one of the big issues that we did in our redesign methodology. The 4 roads that we have, we split up, or we advise the parties. When I'm invited to come in and make a presentation to the parties in the litigation, I break it up this way. There are technical issues, there are legal issues, there are insurance issues, and then there are the below-the-line other issues that, thank God, the mediator has to address, where you've got a custom home and the plaintiff just hates the general contractor. It's beyond repair. That's a real issue. That case will not get resolved until that issue is resolved in some fashion. So I focus on, with the mediator and all of the participants, all of the litigants, we call them stakeholders in our process. Because if you're a litigant, go litigate, as Larry said, go fight. In our process, you're stakeholders. And the stakeholders include the insurance adjusters, the experts that are retained to watch over the process to make sure we're not screwing somebody. Those are all stakeholders. And so it's important that there's a centralized management used to manage this process. We also keep in mind, you know, in all businesses, it's the 80-20 rule. In a typical case, 20% of the issues are 80% of the claim. There are some exceptions, but for the most part. So let's not lose sight of that. Especially on the East Coast, the judges want these small players out as soon as possible. West Coast is a little bit different. And you may hear me refer to the difference between what I call the West Coast model and the East Coast model, because I probably, as a consultant, I probably do more consulting on both coasts than anybody else I know. And there are differences in those models, besides being just in jurisdictions. So early data downloading is really important. In our process, there's no hide the ball. Everything's real time. Everybody has access to the data. The participants decide, and almost in every case, it's all protected for the mediation privilege. And so we put it with somebody like U.S. Legal Services, where all of you generally have accounts, you know how to access it. But if y'all want a more sophisticated approach, we can do that too. We can put data in the cloud. But generally, we don't want to go too far with it. You understand how to work with U.S. Legal, you get onto their system, and you have all the data. You have the photographs after the site inspections. You have it. There's no hide the ball anymore. We changed the paradigm. We changed the process. But like I said, ironically, we kept about 95% of the process. We shrink the time to resolution, as Gary was talking about, because we don't even want to be involved in a project where everybody hasn't taken off the litigation hat and have become stakeholders. I go to a meeting, I walk out. If there's still litigants there, I don't want to be part of it. We understand this is a small, small movement, a la the Tea Party in a sense, but it really is small. We're talking way less than 1%. But on the cases that we're currently working on now, the money that the carriers are saving is enormous. So we shrink the cost of resolution, as already been discussed. We're less now than the cost of indemnity. We're way less than that. We think the neutral experts are the way to go. And when I say neutral, it's not folks that we all know and love. It could be people that you don't like, but you trust. You know, I personally think Chris Allen's a good expert. A lot of people don't like him. He's a very good expert for a lot of different reasons. But if you don't like him, you, the participants, the stakeholders, you select who it is, not me. It's not the mediator's job. It's your job. It's your case. The neutral experts are not always the way to go. There are cases where there has to be a hybrid version to this. So it's not a one-size-fits-all. Our particular program is 100% customizable to every case, every mediator, every set of players. We're not asking you to get into our box. We fit our box to Gary's case. Keep it simple. One of the problems as an outsider non-lawyer is it really gets complicated. When you re-engineer it and you look at it, it's really not that complicated. But people have to do things on a particular time frame to make it happen. We manage that time frame. We help manage that time frame. We also keep the parties fully informed. I think it's important. The minute any player or stakeholder in the process feels like it's hide the ball, it's over. You're done. The process is not going to be successful. We also keep things, as I said, in cloud computing, or we'll use U.S. Legal, basically their cloud computing also, whatever the parties want, whatever the stakeholders want. Our system is fully automated. Once we've started the process and you have talked to us, and we've worked with George Hawkins, and congratulations, George, whoever it is, we have a computer software program that we utilize, and there's reminders sent to everyone. If you're assigned a task and it's 60 days down the road, you get a reminder at 45 days, at 30 days, at 21 days, at 14 days, at 7 days, and at 3 days. Now, if you don't show up prepared, shame on you. And the computer does all that. We're not on the phone making phone calls. And we're using established technology. We are not using, I don't want to say pie in the sky because that's what the cloud is, but we're using proven technologies. These are systems that work. We're already using them. So that's a very short presentation.